Now let us move to module 7, that is powers of arbitral tribunal. Again, very important. As we know, we stay in a country which is specifically regulated by the laws of the land. So all our laws specifically gets their origin from the constitution. So the law will prevail over any other things. So it is important for us to understand that again the Arbitration Act will give specific powers to the tribunal. So let us discuss what are those powers. So the very first is section 16. Again, we have in our initial modules we have already discussed as to section 16 is with respect to jurisdiction and the important principle and doctrine of competence. That is, the arbitral tribunal itself has the jurisdiction to entertain and decide the jurisdictional issues which are raised by the parties. Next is section 17, that is interim measures by the tribunal. Another important provision is section 9 versus section 17 comparison. Now, for example, section 17 is specifically with respect to interim measures by the tribunal. On the other hand, section 9 of the Arbitration Act talks about the interim reliefs by the courts. Now, for example, interim reliefs are interim measures. For example, in cases when a dispute arose between the parties, it will take certain time to appoint the respective arbitrator, maybe jointly or by following section 11. In such cases, there are chances that the subject matter of the dispute or subject matter might be hampered. In such cases, the parties will have right to go for interim reliefs. Those can be any specific injunction, or if the subject matter of the dispute is on is of such a nature that there might be chance of any damage to the property. In such cases, interim reliefs can be sought. So interim reliefs under section 9 can be specifically before the courts and under section 17 are specifically before the tribunal. Now, post 2015 amendment, it is specifically provided that once the arbitral tribunal is appointed, no court should entertain section 9 application. Now, why this is important? Section 9 is specifically before the courts, section 17 is before tribunal. So as I told you, section 9 will only remain effect until arbitrator is appointed. The moment an arbitrator is appointed, section 9 does not have any specific value because everything has been converted into by the arbitrator who have a right to deal with the subject matter. So court will not provide any interference in the subject matter. We are going to discuss various example when it comes to section 9 versus section 17. Now let us discuss section 16 in detail. So section 16 is jurisdiction, which is based on the important doctrine of competence. The tribunal has the power to rule on its own jurisdiction, including objections to existence or validity of the arbitration agreement. The arbitration and the arbitral clause is treated as an independent agreement which is specifically separate from the main content. Again, this we have already discussed that the main contract, in case that contract remains invalid, still the arbitration clause remains valid and it will not automatically invalidate the arbitration clause. Now, timing of objection, again very important. It is advisable for the respondents to take an objection at the earliest, to file their section 16 application at the very early stage in case if they feel that there is an objection with respect to jurisdiction, with respect to maintainability, with respect to limitation. However, in various scenarios when limitation pleas are raised before the tribunal under section 16, those are not required to be decided at the initial stage because limitation is a very important aspect when it comes to understanding the maintainability. Now, for example, provision under Arbitration Act also provides a specific subject matter with respect to limitation. For example, the Limitation Act directly applies to arbitration as well. This means the arbitration proceedings are required to be initiated within 3 years from the date of dispute. This is very logical. For example, in case of recovery matters, the suit should be filed within a period of 3 years. Okay. Now, in the respect of limitation pleas, which are taken by the parties, those are also required to be addressed before the arbitrator under section 16. Next is the objection that the claim exceeds scope must be raised as soon as the matter alleged to be beyond the scope of the pleas that those are raised. Now, in case if the party is aggrieved that arbitrator is exceeding its important powers which are given under the act, in that case, definite remedies can be taken from the respective court. Generally, arbitrators are very reluctant. They will not exceed their limitations and powers given under the act. The tribunal may rule on jurisdiction as a primary question or in the final award. Again, very important aspect. Many of the judges or the arbitrators, for that matter, will hear both the parties in detail and then come to a conclusion with respect to jurisdiction. Okay. Next is if the tribunal rules that it has jurisdiction, the party may challenge it only under section 37(2)(a) by an appeal or wait and challenge the final award under section 34. This means the orders of the respective arbitrators are challengeable under section 37 as well, or else the parties will definitely have an option to wait for the final award and then challenge the award under section 34 of the act. Again, with a very limited ground. Tribunal's ruling that it has no jurisdiction is appealable under section 37(2)(b) of the Arbitration Act. Again, very important provision. Now, appellate jurisdiction is given to respective court who will definitely have a right and power to entertain the respective subject matter of the case. Now, let us discuss section 9 versus section 17, an important comparison. So, first, let us get a clear idea. Section 9 is filed before the courts, that is the judicial authority. Section 17 is before the arbitral tribunal. Now, this is very logical that section 17 can only be filed before the tribunal once the arbitral tribunal is appointed. Okay. In case if the arbitral tribunal is not appointed, then parties will have a right to go approach the court. Now, when parties file section 9 application, it is very important for the concerned petitioner to prove before the court that they actually have a manifest intention to go for arbitration. Because in case if they have no intention to go for arbitration, in that case section 9 can be rejected by the courts, because section 9 can not be filed just to get interim reliefs from the court and not to proceed for arbitration. These are again interim reliefs of very specific nature. They will not be deciding, the courts will not be deciding whole of the subject matter. Hence, these are on very, very, very limited grounds. So the first parameter is authority. So under section 9, authority is with the courts, that is the judicial authority. Section 17, the authority is with the arbitral tribunal. Stage at which section 9 and section 17 can be filed. So before, during or after the arbitral proceedings. Again, very important. Now, section 9 can be filed during the proceedings which are going before the before the arbitrator is appointed. Now, in such cases, section 9 application is very important to get interim reliefs from the court. Similarly, an application can be filed before the arbitrator when arbitration proceedings are going on. So, section 17 comes into effect only during the arbitral proceedings and not otherwise. Next is scope of relief. Very wide, wherein the reliefs including preservation, interim custody, injunction, appointment of receiver, securing amount in dispute, these reliefs can be sought. Now, after the amendment of 2015, Section 9 and Section 17 are very much equivalent when it comes to powers. However, the only difference between the two is the authority before which it is to be filed. That's all. Otherwise, everything remains the same. Enforceability. Order enforceable just like a court decree, enforceable as if it were a decree under the CPC. Again, very basic difference. Now, when it is preferred, so Section 9 applications are preferred in case there is any urgency. In Section 17, at any point of time, when the party think that this is necessary during the proceedings which are going on. Now, appeal. So appeal under section 9 can be filed under section 37(1)(b) of the Arbitration Act, and under section 17 it can be filed under section 37(2)(b) of the Act. So both the orders, section 9 order, section 17 orders, are appealable. The very important thing which is important for the parties, that is the one who has filed section 9, is to show that they are actually taking steps for appointment of arbitrator when section 9 is filed. That is manifest intention to arbitrate. Section 17, interim release by the tribunal. The tribunal may grant interim measures at the request of a party. Post 2015 amendment, section 17(2) provides that orders of the arbitral tribunal under section 17 are enforceable as if they were orders of the court. Now, as I told you, there was a gap between the provisions under Arbitration Act when it comes to section 9 and section 17. Now that gap has been removed by the amendment because there should be limited intervention of the court and major power should be with the tribunal. This is the logic. Now, the reliefs which can be asked under section 9 and section 17 are same in nature. However, the only difference, as I told you, is with respect to the forum and with respect to the time. That is very important. Section 9 relief can be asked before the court only before the appointment of the arbitrator. That is again very important. Now, tribunal has discretion. That is, parties may make out a prima facie case, balance of convenience, and irreparable loss. This is again a triparty test, as it is important when it comes to judicial hearings as well. So, in cases of to get injunction, these are the again very three important elements: prima facie case, balance of convenience, and irreparable loss to the party. These three factors are very important to prove before the authorities. Then only specific interim reliefs and interim measures can be asked for. Now, next is Section 9, Clause 3. Again, what was the impact after the amendment of 2015? Once the arbitral tribunal is duly constituted, court shall not entertain Section 9 application unless the court finds that circumstances exists which may not make the remedy under Section 17 efficacious. That is very important because Section 9 cannot be entertained by the court when the arbitral tribunal is already in place. The reason for this is court will direct the parties to seek relief before the tribunal rather than getting before the court because arbitration tribunal is already in place. However, in certain circumstances which are required to be proved by the parties, if the parties make sure that and they prove it before the court that this section 9 is necessary because section 17 is not going to give them any relief, in that case, section 9 can be filed before the courts. Now, what is the rationale behind this? Minimizing the judicial intervention, keeping the proceedings within the tribunal. This is very important. Why only minimum intervention? So that everything can be decided and resolved at a specific place only. Now, efficacy is again very important because in case if powers are given to two authorities, then there are chances that the dispute will not be decided in a proper manner. Hence, powers lies with a single authority only.